Hello everyone, welcome to Aptiplus Academy for Resource Officers. Today, here again I am for daily news and editorial analysis for 8th, 9th and 10th of July 2024. And this editorial analysis is important for all the government exams in India, and especially this editorial analysis is catered to the syllabus of UPSC prelims, mains and interview process. So for this reason, bear with me till the end of this video, and have been covering this daily news and editorial analysis since many months. And Sahil sir will also be taking the classes for daily news and editorial analysis for Thursday, Friday, and Saturday. So bear with us for the editorial analysis of both the Hindu and Indian Express. So let us begin the analysis. So first, we let us discuss about the mains practice questions. So since mains is very near, UPSC mains will be there after a few months. So for that reason, I have brought some important questions for the UPSC mains, and these questions are from the current affairs that is there in news. So recently, Prime Minister Narendra Modi visited Russia for the bilateral visit, and this visit is very important because this is for the first time that Indian Prime Minister is visiting Russia after election as the priority. So what used to happen in India is that the Prime Minister used to visit the neighboring country first. So the neighboring country was the priority of visit of Indian Prime Minister after the election. But this time, going against the traditional flow, the Indian Prime Minister has decided to visit Russia instead of visiting the neighboring countries. So for this reason, this visit is important. And the question for the mains is discuss the significance of Prime Minister's recent bilateral visit to Russia and analyze the complexities in India-Russia relations in contemporary geopolitical context. So comment the answer of this question. You can comment the answer of this question as well, or you can practice writing the answer of this question at home. And the next question is highlight the authority of presiding officers in expunging the remarks and analyze the challenges associated with its application in digital age. So recently, we have seen that the muting of mics in the parliament. So leader of opposition had opposed the chair in the house, that the mic of the leader of opposition was muted during the debate. So for this reason, the voices of the opposition party, whether they are important or not, and the freedom of speech in the parliament is important, whether that is important or not, and what are the provisions for the freedom of speech in the parliament of India has to be discussed. So for this reason, this question is there. So discuss, write the answer of this question, practice writing the answer of this question at home. And next question is analyze the effectiveness of disaster risk reduction initiative by Indian government in the context of this stampede prevention. So recently there was stampede in Hathras in UP. So for this reason, you need to understand what are the initiative that the government of India has taken so far as to prevent the stampede situations around the India or in different states. So this topic is also important because the stampede is happening in many states in previous years. And recently it also happened in UP. So for this reason, this topic is important. So you can you can try answering this question as well, and discuss the need and challenges associated with providing social security for gig workers in India. So gig workers is also important term because recently Karnataka government has implemented a law to provide the social security to the gig workers in Karnataka. So for this reason, this topic is important. So gig workers are basically the workers who basically uses the platforms or who are on the outside the traditional employee framework. For instance, the Swiggy delivery boys, freelancers which are working as a freelance in various companies. So they are called the gig workers. So the gig workers population and the number of gig workers in India is increasing. So for this reason, this topic again becomes important. So these questions are the practice questions. So try practicing these questions at home, especially before the mains. Okay? And those who are not writing the mains as well, they can try answering this question at home. So the first topic of discussion for today is the religious practices versus law. So this article appeared in the Hindu as well as in the Indian Express, and this topic is very important for the UPSC mains perspective. That is the GS paper 1, GS paper 2. So in GS paper 2, this topic is important, and the context is some essential religious practices may be contrary to the constitutional ethos and values. So in India, there is freedom of religion. Okay? Article 25 of the Constitution of India provides for right to profess, practice, and propagate the religious beliefs. You can have your own religious beliefs as per the Article 25. Okay? So the religious rights and practices are protected under Article 25. But these religious practices, the freedom of religion, sometimes affect the rights of individuals. The human right violations might be affected. The animal rights might be affected. So for this reason, we need to balance the religious practices with the law. So this article talks about it. Okay? So there are essential religious practices. What are the essential religious practices? The essential religious practices are the practices which are very essential for the religion to happen. For instance, to provide to provide some garlands or flowers in the temples, to provide prayers in the temples, to have a priest in the temples. So these things can be considered the essential religious practices. But what constitutes the essential religious practices is basically determined by the Supreme Court of India. So Supreme Court of India in Sirur Mutt case, this is Sirur Mutt case in Supreme Court of India in 1955, held that the term religion will include those rituals that are integral to the particular religion. So Article 25, which talks about the religion, okay, but there is no definition of religion in any of the article in the Constitution of India. So basically the Sirur Mutt case, in Sirur Mutt case, Supreme Court of India declared that only the integral part of the religion are protected. Okay? So the religious practices which are essential are to be protected. But debates arose whether certain the rights or certain practices are religious practices, or they are essential or not. Okay? So for this reason, the debate is ongoing. For instance, in India, there is Dawoodi Bohra community. Okay? So Dawoodi Bohra community, they practice female circumcision, male circumcision, etc. So whether that practice is legal or illegal, whether that practice is falling under the essential religious practices under article, under the Sirur Mutt case, under the the interpretation of the Supreme Court of India, whether that falls under the integral practice of the religion of Dawoodi Bohra community. Okay? So that is one question. And there are cases, for instance, there used to be a debate around the menstruating women are not allowed to enter the temple in Sabarimala in Kerala. Okay? So that was a debate, but Supreme Court of India in Sabarimala case declared that women have right to enter the Sabarimala temple. Okay? So that again protected the right of women. All the women, whether the menstruating women or any other women, can enter the temple. Okay? So that again was the interpretation of Supreme Court of India. Okay? So there are many debates that is going on to balance the religious practices and law, and that is still evolving, because the essential religious practices cannot be defined in any particular community, because every religion has their own religious practices, beliefs. Okay? And some beliefs can go against the community standard of other communities. For instance, during the Kali Puja, there might be killing of animals. There might be a system of giving bhog to the god. ठीक है. So these again violates the principle which is the animal rights. So various organizations such as PETA, ठीक है. So PETA is an important organization which advocates the rights of the animals, ठीक है, that opposes the inhuman killing of animals, giving vogue to God in the name of killing the animals, ठीक है. So that is again another challenge. So these examples can be quoted, okay, when you are writing the answer to balance the religious practices and law, okay. So religious practices and rights versus legal and constitutional issues. So Article 25, as we just discussed, provides for the right to profess, practice, and propagate religion. Okay, and that the religion is to be balanced by the Supreme Court, whether particular belief constitutes the essential practice in the religion or not. Okay, so that is to be determined by the Supreme Court. You have to remember this Sirur Mott case. Okay, Sirur Mott case is very, very important. You can quote the Sirur Mott case in various answer writing, and sometimes UPSC might also ask the questions directly in prelims regarding the Sirur Mott case. Okay, so you have to know this. And the judicial scrutiny and intervention. Okay, so judicial scrutiny determines whether the religious practice is integral to the religion or merely superstitious, arbitrary, detrimental to the public interest. So whether the religious practice of particular religion is merely superstitious, arbitrary, or detrimental to the public interest or not is to be determined by the Supreme Court of India. And court intervened to uphold the constitutional principles, ensuring that religious practices do not infringe upon the rights of individuals, conflict with the constitutional moralities. And this is again an important term, the constitutional morality. Okay, so the religious rights, the religious beliefs should again be in consonance with the constitutional morality. So what is constitutional morality? Constitutional morality means that the constitution does not merely say that the law has to be according to the constitution. Okay, so it is not necessary that constitution has to abide by the constitution only, but the constitution morality means whether certain rights or certain practices that is being practiced by the people is moral or not, whether they are right in the moral sense or not. Okay, so that is an important term. Okay, constitutional morality. So the essential religious practices has to be balanced with the constitutional morality. And in 2017, Supreme Court upheld the right of Sikh individuals to wear the turbans in workplaces, considering it right under Article 25. Okay, so Supreme Court in various cases, we discussed about Sabarimala case as well. We discussed about Dawoodi Bohra case. Okay, so Supreme Court in 2017 as well declared that the right of the Sikh people to wear the turban as the integral part of the religion, that is the essential part of Sikh community. Okay, so that is under the Article 25. So Supreme Court ने ये भी declare किया है in 2017. Okay, so Supreme Court in various instances has delivered such judgment, and public order and morality practices that disrupt the public order, promote discrimination, or pose health hazards may face legal challenges. Okay, so if some practices are there which disrupt the public order, okay, which promotes the violence or which discriminates certain community, for instance, not allowing the lower caste people to enter into temple, not allowing menstruating women to enter into the temple. Okay, so if these practices are there in certain religion, that practices might be considered constitutionally immoral, that practices might be considered inhuman. So for this reason, that those practices can be considered as illegal by the Supreme Court of India. So those practices can be declared not part of the essential feature of the certain religion. Okay, so the state has authority to regulate this or restrict the religious practices that undermine the public order, morality, health, and even if they are considered religious by certain groups. So Article 25, we discussed that Article 25 provides for the right to profess, propagate, and your belief system. Okay? So right to profess, propagate your religion, right? Your belief is there on Article 25. But Article 25 subclause 2 also provides that there are certain reasonable restrictions. Okay? So that reasonable restrictions can be imposed by the government of India, by the parliament on the conditions of public order, morality, health, or even if they are considered religious by certain groups. Okay? So even if certain community considers certain religion or certain belief to be integral part of the religion, then that part can be considered illegal by the parliament as well. So not only the judiciary has the power to declare certain religion as illegal, but the the parliament also has right to declare certain certain part of religion, certain belief as illegal or immoral. Okay? For instance, the Supreme Court, the Parliament, Indian Parliament in 2019 enacted the law, which is the Muslim Women Protection of Rights on Marriage Act 2019. Okay? So this law basically criminalized the triple talaq system in the Muslim community. So among the Muslim community, what used to happen is that by uttering talaq three times, okay? So by uttering talaq three times, the women used to be given divorce. Okay? So that system was declared illegal by the parliament under this act. So parliament also can declare certain religious beliefs to be the illegal, to be not essential part of certain religion. Okay? So this is another important point. So you can quote these examples, okay, in your answer. And right to privacy and human dignity. Individuals have right to privacy and dignity in practicing their religious beliefs, protected under Article 21. Okay? So Article 21 talks about the right to life. Okay? So Article 21 talks about right to life. But Putta Swami judgment. So you must have read about the Putta Swami judgment. So this is a landmark judgment of the Supreme Court of India, where the Supreme Court declared that the right to privacy is integral part of the fundamental right under Article 21. Okay? So right to privacy is again, is there in the certain religious community. Okay? Courts balance these rights with the societal norms and public interest, especially in cases where the religious practices might conflict with the modern standards of human rights and dignity. So if certain religious practices are private in their own religion, but if these religious practices again violates the rights or dignity of an individual, that can be declared unconstitutional by Supreme Court of India. Okay? Article 25(2) of Constitution gives powers to state to make laws with respect to the regulation of economic, political, and the other activities related to religion. Okay? So again, Article 25(2), we talked about it. It talks about the reasonable restrictions on freedom of religion in India and equality and non-discrimination. The practices that discriminates based on caste, gender, we talked about it. The lower caste people in some temples are not allowed to enter. Gender-based discrimination, menstruating women or women in general sometimes are not allowed to enter into temple. And other criteria are subject to legal scrutiny under the anti-discrimination laws. Okay? So the Constitution also provides for the non-discrimination, okay, based on these criteria. So Article 14, which talks about right to equality of everyone. Article 15, which prohibits discrimination based on religion, race, caste, place of birth, or sex. Okay? So based on these 5 criteria, discrimination is prevented under Article 15. And these discrimination is not allowed even if certain practices are considered essential by certain religious community. ठीक है. So for this reason, Supreme Court and the Parliament can make laws to prevent the human right violations or the rights of the individual. ठीक है. And issues arising from religious freedom in India, conflict between the religious practices and gender equality. ठीक है. So we talked about it. Gender equality, Sabarimala case, we discussed about it. ठीक है. Gender equality might be affected due to the religious freedom. ठीक है. Due to unwarranted religious freedom, public order and religious practices. Some religious practices or rituals can lead to public disorder, social unrest, law and order issues. ठीक है. So this is again an important challenge. For instance, use of loudspeaker or animal sacrifices. Recently, the debates are going on whether the loudspeakers can be used by the religious communities in the market area, etc. ठीक है. So this is again an important public order issue. And interfaith marriages and personal freedom. ठीक है. So interfaith marriages is again opposed by certain religious community. For instance, there is case of Hadiya. So these examples are very much important for all of you. ठीक है. So you can note the examples. Hadiya. Hadiya was a woman from Kerala, and she basically converted to Islam and married a Muslim man in 2011. But due to the opposition from the family of Hadiya, led to the legal battle. So legal battle was fought, and the courts declared that marriage to be legal. The Supreme Court of India declared that marriage is legal. ठीक है. So Supreme Court basically acts as the protector, ultimate protector of the human rights in India. ठीक है. So Supreme Court has done various justice through the judgments. ठीक है. So for this reason, Supreme Court is the guarantor of the fundamental rights in India. So ठीक है. So that is important. So for this, so you can quote these examples. ठीक है. So interfaith marriage में अभी affect हो सकता है. So interfaith marriage is another hurdle in the freedom of religion. ठीक है. And there are cases of khap panchayats. You must have heard about the khap panchayats. You can quote them as well. So khap panchayats. So these points can also be important for the social issues. ठीक है. Social issues topic के लिए भी important रह सकता है UPSC mains में. And khap panchayats are basically panchayats which are like kangaroo courts. Have you heard about the kangaroo courts? So kangaroo courts are basically trials which are conducted by the people by taking law and order in their own hands. ठीक है. So khap panchayat में ये होता है कि the elders in the village decide the justice delivery system. They decides who can do what, which community can do what, which community cannot do what. ठीक है. What are the rights of the people in their village? So basically, the elders, the group of elders decide the fate of individuals in the village areas in certain part of India. So khap panchayat mein there are cases, for instance, the people who had the adultery, or the people who married the person from another community were basically killed by the public. ठीक है. So such kind of vigilantism happen in the khap panchayats. So for this reason, the khap panchayats can also be quoted. ठीक है, here. And the caste based discrimination and religious practices. ठीक है. So certain religious practices perpetuate the caste based discrimination. ठीक है. So you can quote the caste-based discrimination happens in khap panchayats as well. For instance, in Haryana, there was a case that a woman married with the person with the lower caste the people. ठीक है. So when women from upper caste community married a man from the lower caste community, the man who married that woman was taken by the khap, and khap basically killed that person. Okay, so that kind of justice is given in the khap panchayats. You can quote them. And the religious practice of anga pradaksinam. Okay, so this is very important example. So anga pradaksinam is practice that is there in various temples in South India. where the Dalits and non-Brahmins rolls over the leftover plantain leaves. Okay, so basically you can see the picture here. So these people roll over the plantain leaves, and this is again the violation of their rights under Article 15 and Article 17, which prohibits the untouchability. So untouchability in India is prevented by Article 15, 17, and Article 15 provides for prevention of discrimination based on religion, race, caste, sex, or place of birth. Okay, so this is another example you can quote. So these are all important examples that you can quote, and these are all important cases about the religious practices and law, how they are to be balanced and what are the challenges. And there is secularism versus religious dominance as well. Okay, so debates over the state funding or support for religious institutions is also there. So there are debates going on that whether states should fund the religious religious institutions or not. But India is a country where there is no state funding for the religious or the any religious sect. Okay, so India is a secular country. Okay, so but there is a difference between the secularism in India and the secularism in West as well. That is another topic of discussion. Okay, so in West, what happens is that the religion is completely separate from the state. But in India, state can interfere in the religious processes. For instance, the Sirur Mutt case. In Sirur Mutt case, Supreme Court declared that certain part of the religion can be declared essential. Okay, so that is a kind of intervention by the judiciary. And for instance, the triple talaq case. Okay, the enactment of the law to prevent the triple talaq by the parliament, that is again intervention by the state on the religious affair. Okay, so state can interfere in the religious affair in India, but in US or any other countries in West, there is no provision of interference of the religious practices by the state. So state is completely outside the domain of this religion. So that is the main difference between the Western form of secularism and the Indian secularism. Okay, so there is debate in India that the certain religious communities are being funded by the state to gain their favor. Okay, so for this reason, this is another issue. And so way ahead, what we can do to prevent such kind of religious vigilantism or such kind of religious issues that is going on in India, to balance the religions and law. What is the way ahead that is there in India? The promotion of interfaith dialogue and understanding. So that is important point. So interfaith dialogue and the understanding can be promoted. For instance, the United Nations Alliance of Civilizations, which is UNAOC, promotes the interfaith religion around the world. So you can quote these type of examples from the United Nations or from the global level. And education on religious pluralism and human rights. Okay, so education curriculum can be changed in such a way that the religion pluralism or the human rights is promoted. Okay, there should be promotion of human rights and religious pluralism, so that one religion is respected by another. Okay, so that is another way ahead that we can do. Legal reforms to strengthen the constitutional safeguards. Legal reforms can be taken. For instance, amending the SC/ST Act, making laws on religious vigilantism. Okay, so for instance, the cow vigilantism is going on in different part of India, and public lynching are going on by the cow protectionist in India. So these things can be prevented by making laws to prevent the cow vigilantism. For instance, Manipur has made a law that prevents the cow vigilantism, that prevents the public lynching. So law against lynching can be made in India. And empowerment of civil society and religious leaders. ठीक है, support initiatives that empower civil society organization and religious leaders to promote the tolerance, address the discrimination and advocate for the religious freedom. ठीक है, so this initiative can also be taken. For instance, the International Center for the Religion and Diplomacy, ICRD, engages religious leaders globally in conflict resolution and the peace building efforts. So this is an important example. So ICRD is taking initiatives where they engage with the religious communities to solve the dispute between different religious communities. Okay, and the international collaboration and best practices sharing. So international collaboration can be done, sharing of best practices by the different countries can be done. So these are the important way ahead. And the essential religious practices test and cases associated with it. So this pointer is important from especially the prelims perspective, and this is also for the main important for the mains. You can quote these essential religious practices and cases in the UPSC mains as well. So we discuss about the essential practices. So essential practice, what constitutes the essential practices in a religion was basically decided by Supreme Court of India in Supreme Court in Sirur Mat case. So in Sirur Mat case, Supreme Court of India first discussed about the essential practices in religion, and this test emerged from various judicial pronouncements where courts examined whether the religious practice is essential to the religion itself. Okay, so this whether the religious practices, the certain belief is the essential practice of the religion was decided by Supreme Court of India in Sirur Mat case. We talked about it, and in this landmark case, the Supreme Court held that what constitutes essential part of the religion is primarily to be ascertained with the reference to that religion itself. The court acknowledged that the practices integral to the religion are protected under Article 25. So that means only the essential practices of the religion is to be protected under Article 25, not any other part. Okay, so that means religious freedom is there, but the Sirur Mat case, the essential religious practices test is basically a test of essentiality. Okay, whether the certain part of religion is essential or not, or whether that religious belief is a part of the right under Article 25 or not. So that is determined by the essential religious practices test. Okay, and Dargah Committee Ajmer case of 1961. So this is again important case, and in this case, the Supreme Court clarified that Article 25 protects the essential religious practices. It does not extend to practices that are superstitious, irrational, extraneous to the religion itself. This case emphasized the distinction between integral practices and those based on mere superstition. So this is again important point. So in Dargah Committee case as well, the Supreme Court declared that the essential practices should not constitute the superstitions, irrational and extraneous to religion itself. Okay, so this is another important case, and Sabarimala case is again important case. We discussed about it. So far as the essential practices test and cases associated with it are concerned, you can quote the Sirur Mat case, you can quote the Dargah Committee case, you can quote the Sabarimala case, you can also quote the other cases such as the Triple Talaq case, you can quote the right to privacy case, Puttaswamy judgment, etc. Okay, so these are all important points, and essential religious practices test and cases associated with it. So this is a different slide. So these were all important points related to the religious practices, essential religious practices versus law. Now moving on to next topic of discussion, next article for analysis, which is the classical language status. Okay, so classical languages are important because the classical languages are the languages which are there in existence for many years, thousands of years in India, and they are recognized by the Ministry of Culture. And recently this topic was in news because Center has decided to tweak the criteria for according the classical language status to certain languages. Okay, So this decision of the center is based on the fact that recently various states has been demanding the classical language status for the various languages. For instance, Maharashtra has been demanding for the classical language status for the Marathi language. West Bengal has been demanding for the classical language status to the Bengali language, etc. So for these demands, to take into these demands, to take into consideration of these demands, the center has decided to tweak the rules for the classical languages. And amid the demand for classical language status, many languages for demand of many languages, this center has decided to tweak the rule for granting the classical language status. So this is the context and the background we discussed about it. Various states has been demanding for it, and the union government has constituted the linguistic export committee comprising of the representatives of the union minister of home, culture, and 4 to 5 linguistic experts at a given time. So this is another important point from the prelims perspective. So linguistic export committees have the members from home. Union minister of home is a member, and union ministry of minister of culture is also there, and the 4 to 5 linguistic experts are also there. So they together constituted a linguistic export committee, and it is said by the president of Sahitya Academy. So this is another important point. So UPSC में there might be option like consider the following statements about the linguistic export committee recently seen in news. Statement 1 might be that it constitutes the following members, which are the Union Minister of Home, Union Minister of Culture, and 3 linguistic experts. Okay, so that statement is incorrect. And statement 2 might be there, which might have statement like it is said by the Minister of State Home. Okay, so that is again incorrect. So it is said by the President of Sahitya Academy. So this type of question is asked in UPSC, and so this type of points you have to remember from the plains perspective. And the Linguistic Export Committee of the Union Ministry submitted the report on October last year, suggesting some changes in the rules to grant the classical language status in India. So for this reason, this topic was in news. So since this topic was in news, we need to understand what are the classical languages there in India, and what are the benefits of classical language status in India. Okay, so you need to know all these points. So these are the classical languages. Okay, so classical languages basically are given the status by the Ministry of Culture. We discussed about it. And India has 6 classical languages as at present. Tamil was declared a classical language in 2004, Sanskrit in 2005, Kannada in 2008, Telugu in 2008, Malayalam in 2013, and Odia in 2014. Okay, so these are the 6 classical languages currently in India, and the classical languages are the listed in 8th schedule of the Constitution of India. So 8th schedule of the Constitution, which has 22 languages. Okay. Out of 22 languages, the 6 languages are the classical languages. Okay. So you have to remember this point. So exam में ये भी pointer रह सकता है कि the all classical languages are included in the 8th schedule of the Constitution of India. Okay, so that is correct. And the criteria for classification of classical languages are language must have recorded history of at least 1500 to 2000 years, and it should possess the substantial body of ancient literature considered valuable heritage. Okay, so it should have the rich heritage of literature as well. So Tamil, for instance, take the example of Tamil. The Tamil has a group of literature in the ancient time, from the ancient time, which are called the Sangam literature. Okay, so Sangam literature were composed over many years, and Sangam literature, for instance, द शिला पट्टिकरम, ठीक है, एट्यूटोगी, देर आर मनी मेघालय, ठीक है, सो मनी मेघालय इज देयर. So all these Sangam literature texts are important, and they have history of thousands of years. So for this reason, Tamil is an important classical language. Okay? So any classical language should have the large amount of literature that dates back to many years, and the literary tradition should be original and not borrowed from any other community. They should be original as well, and there should be discernible discontinuity or continuity between the classical form and its modern counterpart. So there should be a discernible discernible continuity and discontinuity. That means the discontinuity, if any, should be discernible. That has to be easily seen by the observer. We should be able to see that certain changes has happened to that religion or that classical language. Okay, so these are the four important criteria. So these four can be the pointers for the UPSC prelims, and you can quote. Direct questions might also be asked in UPSC mains. And benefits of classical language status. Okay, so special recognition and government support is given to the classical languages. Okay, so languages granted classical status receive the special recognition and support from the government. Okay, and the educational benefits is also there. Okay, which includes the funding for research. So central government through the Ministry of Culture gives the funding for the research in these classical languages. Establishment of centers of excellence. So centers of excellence will be established in various universities or the central universities. Okay, and the professional chairs in the universities. So university में professional chairs भी create किया जाएगा. ठीक है, so this is an important point. And international awards for scholars, ठीक है, international awards for scholars specializing in these languages will be given. ठीक है, and the preservation of cultural identity and heritage. ठीक है, so classical languages play a crucial role in preserving cultural heritage. For instance, we talked about the Mani Meghalai, the Sila Pattikaram. ठीक है, these Sangam literature are important because they are protecting the cultural identity and rich heritage of Tamil people. So for this reason, the cultural heritage and identity will be preserved, and the repositories of ancient wisdom and literature, they are important source of ancient wisdom. What kind of literature used to be there, what kind of intellectual people used to be there, what kind of administrative procedure used to be there in the ancient time, could be determined from their literature. For instance, we can know about the Cholas from the Sangam literature. Okay, we know about the Pandyas, Cholas, etc., which ruled in South India from the Sangam literature. We know about the trade of the South Indian, the rulers such as the Cholas with the Southeast Asian countries and with the Middle Eastern countries from the Sangam literature. So we know about the different type of agricultural practices that used to be done in the Sangam literature in the South India during that period. So we know about all these things from the Sangam literature. So they are repositories of the ancient wisdom and literature. And you can take quote the Sangam literature examples as well. You can also quote about the Sanskrit literature, which includes the Vedas, Upanishads, epics like Mahabharata, Ramayana, etc. You can quote about the Vedas. For instance, we know about the condition of the people, condition of the women during the Rig Vedic period from the Rig Vedas. And from Vedas, we also know about the later Vedic period and their life during that time. Okay, so they are very important repositories of the ancient wisdom. And understanding linguistic and cultural diversity, they are essential for understanding India's diverse linguistic and cultural landscape. Okay, for instance, Sangam literature, we talked about it. Okay, it was composed between 300 BCE to 300 CE, covering the diverse themes including love, war, and ethics. So all these can be sourced from the classical languages. So for this reason, the classical languages are very important and they needs to be preserved. So these are all important facts about the classical languages that you need to know. Now moving on to next topic of discussion and the next important analysis, which is the new provisions for police officers. So recently we have seen that government of India will be implementing the new criminal laws. That is, the government of India has recently implemented the new criminal laws, which replace the three important criminal laws, which are the Indian Evidence Act, okay, Indian Evidence Act. Second one is the Indian Penal Code. Third one is Code of Criminal Procedure. So these three laws are being replaced by the central government, okay, and they have been replaced by new criminal laws, and they are called the Bharatiya Naya Surakshya Sanhita, BNSS. So BNSS is new criminal law, and this is being made effective from 1st of July 2024. Okay. So for this reason, this topic was in news, and you can see the article. So this article appeared in the Indian Express, and this topic is important because to this new criminal law, new rules has also been being distributed by the central government to police officers, because new provisions has made different rules for the police officers as well. So different standard operating procedures for arrest, for custody, etc., has been made by the government of India. So for this reason, standard operating procedures have been issued by the Bureau of Police Resource and Development to guide the police officers in implementing the new provisions of the criminal laws. So Bureau of Police Resource and Development has basically given the new laws or new rules or new provisions to the police officers, so that the police officers are aware of the new criminal laws. Okay? So basically, till 31st of June, police officers used to arrest people based on the evidence of Indian Evidence Act, based on the sections of IPC, CRPC, etc. But from now onwards, different sections have to be implemented. So for this reason, the police officers have to be trained. They have to know about the new laws that have been made by the new provision of the criminal procedure, the Bharatiya Naya Surakshya Sanhita. So for this reason, this provision, this news topic was in news. So what are the provisions of the new standard, for the police officers under this Bharatiya Naya Surakshya Sanhita? Okay. So new standard operating procedures are rules for registration of FIR. So this is an important. So the officer in charge of police station must register the FIR regardless of jurisdictional issue. Okay. So even if a certain person goes to a police station, and even if that person does not belong to the jurisdiction of that police station, then also that police officer has to register the case for him. And that kind of FIR is called zero FIR. So this term is very important. Zero FIR means registering case in the police station which is not under the jurisdiction of that police station. So zero FIR term is very important. So zero FIR has been made integral part of this new standard operating procedure. Okay. So the police officer must register case under zero FIR, and non-registration of FIR can lead to penal action under the Bharatiya Naya Surakshya Sanhita. Okay. So penal action will be taken against the police officer who failed to register case under this new law. And FIR can now be filed electronically alongside the traditional oral or written methods. Okay. So there are three methods of registering FIR as per this new standard operating procedure, which is the electronic means, oral means, and the written means. Okay. So written means. So these are three procedures. And other provisions, so far as the other provisions are concerned, videography requirements, mandatory videography during the searches, section 185. Okay. So videography has to be done when the search operation is being conducted by the police officer. So this is a new important criteria. And the during the property seizures and the crime scenes. So at the crime scene, during the property seizures, okay, during all these times, the videography is to be done by the police officer, and the negligence in conducting the videography can benefit the accused, emphasizing the need for proper training and equipment for the investigating officers. And Saksha app. This is also important. Saksha app. So this app is basically a mobile phone application to help the police record the crime scene. So crime scene can be recorded by police officers using this Saksha app. So this kind of question is directly asked in UPSC in one-liners. Okay. So Saksha app recently seen in news relates to what? And this app is basically related to the video recording by the police officers during the search and seizure procedures, and they can also geotag the crime scenes. Okay. So it enables the police to upload recorded evidence to cloud-based platform, and this data is accessible to various agencies like judiciary. So judiciary can access it, prosecution, and these cyber forensic experts. Okay. And there is provisions of arrest. Information about arrested individuals must be prominently displayed at police stations. Okay. By the assistant sub-inspector or higher. Okay. So information about the arrested individuals must be displayed to the public by the ASI and the officer which is higher in rank than the ASI. And the special restrictions are imposed on the arresting elderly or infirm persons, requiring the permission of deputy superintendent of police for certain offences. Okay. So the police officers cannot directly arrest the elderly people, okay, or infirm people which are basically disabled people. So before arresting the infirm people or the physically challenged people or the elderly people, they have to take the permission of the deputy superintendent of police for certain offenses. Okay. So this is an important point. Now, other important points are timelines for medical reports and investigation. Medical reports in rape cases must be forwarded to the investigating officers within the 7 days of submission to the magistrate. Okay. So this is an important point. So medical जो report है which is related to the rape cases must be forwarded to the investigating officer within the 7 days of submission to the magistrate. Okay. So this again prevents the leaks in the system. And investigations of the POXO cases must be completed within 2 months of the offense being reported. Okay. So this is again important point. Within the 2 months, the case is to be completed. The investigation is to be completed in case of POXO, which is the prevention of the sexual offenses against the children. Okay. And the handling of electronic evidence. So section 193(3)(h) mandates that maintaining custody records of the electronic devices due to their susceptibility to tampering. Okay. So custody records has to be protected, and the police officers are required to upgrade their skills to ensure the integrity of the electronic records. Okay. So police officers need to upgrade their skills and to protect the electronic records, because most of the things now are being done electronically. So you can note one thing, that in the new criminal law, the standard operating procedure basically emphasizes upon the electronic evidence. Okay. So in everything, the electronic evidence or the electronic means is to be inserted. Okay. So for this reason, the police officers has to prepare themselves. The police officers has to be trained to handle these electronic records. And the definition of Terrorist Act, section 133 of the Bharatiya Naya Sanhita defines the terrorist acts. Okay. And the terrorist act can be under the UAPA or any other law. Okay. And the decision to register cases under this section or under the Unlawful Activities Prevention Act UAPA rests with SPs considering the factors like the seriousness of the offense and the investigative requirements. Okay, so whether the case is to be taken up or not under the terrorist act, okay, under the UAPA, is to be decided by the superintendent of police. Okay, so this is an important point. So these are important provisions so far as the standard operating procedures for the police under the Bharatiya Naya Surakshya Sanhita is concerned. So these are all important three topics which were there in news. So these topics are going to be very, very important for the UPSC prelims, mains, and interview. So comment your opinions, your points. If you have any doubts, you can comment your points in the comment section. We will be coming up in the next session. In the next session, Sahil sir will be taking the class. In the next week, I'll be coming back again with those important topics which will be there in news next week. Okay. So till then, stay tuned. I'm signing off for today. We'll meet again in the next video. Take care. Thank you.